Hello everyone, greetings to all watching the video. I welcome you all to another episode of Convo with Apricus. Friends, this episode is a continuation of previous one which we had with Dr. Shalini Rohilla Panigrahi on Insolvency and Bankruptcy Code. Let's start the discussion, ma'am.
Thank you, Reshu. I'm just sharing my screen. Hello, friends. In the previous lectures, we gave a basic introduction about the Insolvency and Bankruptcy Code 2016. So here we have I have devised a modules-wise course. So this is the first module, and we will be covering the following areas. First, we will see the abbreviations which are used time and again in this code. Though they are they will look elementary, but these are the basic abbreviations which will be time and again used in the code. So we have to get familiar with these abbreviations. Then what are the features of this code? We will be able to answer these questions after this module discussion. Why codification of insolvency was required? The brief background about the enactment of the code. Why was this code enacted? These basic questions have to be answered and understood first. Then we can go into the depth of this code. What was the objective? Why this code was required when there was already a legal framework for corporate insolvency in various laws? What was the legal framework which dealt with the corporate insolvency prior to IBC? The features of this code and the amendments which have been carried so far. These are the abbreviations. First of all, AA, adjudicating authority. The adjudicating authority here is the NCLT. AR, authorized representative. Corporate debtor, CD. Chief executive officer. CIRP, corporate insolvency resolution process. When we go through the newspaper these days, you will be listening to these terms. You will be seeing these terms, CIRP. So we have to get familiar with these terms first. Committee of creditors. DRAT, Debt Recovery Appellate Tribunal, which we discussed in the previous lectures also. Expression of interest. Creditors, financial creditor, operational creditor, FCs, financial creditor. The Bankruptcy Code, Insolvency and Bankruptcy Board of India, which take care of all the formalities and implementation of this code. IBC, as you know, Insolvency and Bankruptcy Code. It is not an act, it is a code, complete unified code. It's an umbrella legislation, basically. Then insolvency, the day from which the insolvency proceedings start, it is called insolvency commencement date. Information memorandum, IM, which gives all the information about the creditors when the case is filed with IBC. When the IBC proceeding starts, all information is collected with the information memorandum. The professionals which deal with this proceedings are called insolvency professionals who take care of all these proceedings. And the agency which takes care of appointment of these professionals is IPA, Insolvency Professional Agencies. Then there are various other entities like IPE, Insolvency Professional Entities, and the Resolution Professional, very important facility, who take care of all the proceedings right from the resolution till the liquidation, IRP, Interim Resolution Professional. And in many cases, he becomes the resolution professional also. In the beginning, interim is appointed, later it becomes permanent by the voting of COC. The COC agrees, he becomes a resolution professional also. IU, information utility, all the information is collected with these authorities. Then the date on which the liquidation starts, if the resolution is failing, the company will go in liquidation. So the date from where the liquidation starts, it will be that LCD, liquidation commencement date. Then the entities which are involved in this insolvency includes limited liability partnership also. This code is applicable to LLP also. And then Ministry of Corporate Affairs, everyone knows it's a very common term. Then MSMEs, micro, small, and even this code is applicable to these enterprises, but still these provisions are not yet notified. NCLT and NCLT, these terms you will be hearing time and again, because these are the tribunals which helps the enactment of this code. Whatever the resolution comes out from the IBC proceedings, that has to be approved by NCLT, National Company Law Tribunals. They have to give a nod to the resolution, whatever the resolution comes out of. They have to approve it, only then the proceedings will start further. Then operational creditors, these are the various categories of creditors who can go in insolvency. Financial creditor, operational creditor, and the creditor himself can go under the insolvency. He can also initiate insolvency against itself. Then the resolution applicant who applies for the buying of the going concern. So they are the prospective resolution applicant who are interested in buying the going concerns which are sold off after liquidation. Then RBI, everyone knows, Reserve Bank of India, request for resolution plans, IRFRP. Then resolution professional, the IRP sometimes becomes the resolution professional also. Interim can become the resolution professional also. SARFAESI, we know this is the act which was enacted in 2002 for selling of the assets which are secured assets. SCC, Stakeholder Consultation Committee, and SEBI, Securities and Exchange Board of India. Now, what are the features of this code? Insolvency and Bankruptcy Code, this is a legislation which was enacted in 2016. It's an umbrella legislation which covers both corporate as well as individual entities. The provisions which are related to insolvency and liquidation, related to the corporate persons, these came in force on December 1st, 2016, whereas related to personal guarantors, they came in force in 2019, December 1st. So the individuals and partnership provisions are yet to be notified. They are not operational yet. Why the codification was needed when there was already law in place? Again, I'm repeating these things here also, to bring greater coherence in the law and to find all the provisions in one place rather than going under various acts like companies law or some special laws which were there earlier. There was a need that there should be one code where all the provisions could be there for the different stakeholders. To end this dilemma of the various stakeholders, which were that dilemma was created because they were acts, but they were not that successful. So when this code came, that act to the repealment of various acts like Presidency Town Insolvency Act, Provincial Insolvency Act, and 11 amendments were carried in the Companies Act 2013, an RTDBI Act, and a Securitized SARFAESI Act 2002 to give back to the new. So there were various amendments which were made to make this code successful, to bring this code in place. And the provisions of the code are not coming in one go. They are coming in various phases. Now, brief background regarding the insolvency code has to be understood. Why this code come? What were the conditions? What were the circumstances which led to the enactment of this code? There were various reforms committee in the form of BLRC, Bankruptcy Law Reforms Committee was formed, and it placed its report in 2015, which states that the insolvency process are highly fragmented in India. The power of the creditors were given under different acts like SARFAESI, DRT. So time was now felt that those were not that successful, and the creditors were really facing many problems because they gave loan and the defaulters were creating defaults. Still there was no rescue for them. The debtors was flowing away from the country. So all these circumstances led to the various conflicts between the creditors and the debtors, and cases were reaching in the various forms like BIFOR, DRT, and pendency of these cases were increasing day by day. So this led to the brainstorming of the various stakeholders, and they came with the enactment of this code. Now, various types of protection are given under this resolution framework. Individual precedent is set by the case law, which helps flesh out the statutory law. There may be cases where the new substantive law and the statute and the precedents are silent. So court has also placed a very important role. They have made significant impact on the interpretation of various existing insolvency legislation. Even this code, IBC, has been interpreted by the various courts in different ways. So court has a very important role in making this legislation a success. Now, World Bank also impacted. World Bank reports came in 2014, which state that in various countries, insolvency proceedings are carried out in a very short span. Like in Singapore, it is just 8 months. In other countries like UK, it took 1 year only to complete the insolvency proceedings. But when we see India case, like if the case is registered in BIFR or Sikh Industries Act 1985, it took years. And India was thought to be the youngest republic where so many dynamic entrepreneurs were there. So the growth was really crippled. And because the assets were blocked, so a need was felt that there should be a revolution now. There should be a code which deals with all these flaws. And what is the crux of bankruptcy code? The speed. The speed is essential. Why? Because a time limit is given in the act itself, 180 days. The resolution has to be winded up in 180 days. There is no extension unless and until there are request is given, but at the maximum that can be extendable to 90 days and not further 330 days. In all those liquidation, all those proceedings inclusive of that litigation expenses and all litigation time, whatever is taken, but 330 days is the end limit. It cannot exceed 330 days. First, when the calm period has helped the organization afloat with full clarity of ownership, significant decision cannot be made without effective leadership. The firm will tend to fail. So if the company is going in liquidation and that falls in bad hands, so what will happen? That company which might be flourishing in other hands, it will not flourish here. The longer the delay, the more likely that liquidation will only be the answer. So earlier there was the liquidation was answer, means that company has to be sold off. But this code has given a chance of revival of the companies because there is a resolution plan. If that resolution plan is successful, that company can be revived. What happens when liquidation happens? Liquidation tends to go down with the time as assets, whatever assets are there of the company, they can depreciate. So this calls for a resolution process and not liquidation. In all countries, bankruptcy laws are under significant changes because if there are no change, it will be the growth will be stagnant. We have to grow. We have to learn from other countries as well. So here, India took a very good step and very foresightedness was shown by our stakeholders. Our government took a very important role. We played a very important role in enactment of this code. The BLRC report went on to state that India is the youngest republic where there are so many entrepreneurs which are coming up. Yet these game changes and growth drivers were crippled by the environment. So all these factors have led to the enactment of this very important code. One more thing, that previous legislation like SICA, RDDY Act, they completely failed. So the solution was needed, how to tackle with these menaces. What was the objective with which the code was created? First of all, it was enacted as a critical building block of India's progression to maturity of the mature market of the economy. It addressed the growing need of the comprehensive law which will deal with the insolvency of debtor, maximizing the value of the assets of the company, creditors. Then, and to make that entity viable business, not unviable, not to close it. Because earlier there was like to close the business, to sell it off. But now there is a process of reviving those companies which have scope of revival. So the first objective is resolution. If the resolution fails, then the second process is liquidation. To maximize the value of the assets of those companies which are under debt. Third objective is to promote entrepreneurship, availability of credit, and balancing of interest of both creditors and debtors. Balancing of powers of both. Here, earlier it was debtor driven. Whatever the debtor does, that was to be followed. But now, creditor has full control over the assets of the debtor. Now, this paragraph is like objective of the code is the crux of the IBC. If this is understood, half of the work is done. The act to consolidate. Consolidate means to whatever provisions related to insolvency are brought under this code. Earlier, they were scattered under various laws like company law, other insolvency acts, and consumer acts. But now all these provisions are brought under this code, and it deals with all variety of stakeholders like corporate person, individual, partnership firms, LLPs, MSMEs. They have tried to cover the maximum stakeholders. And to how the maximization of the assets will take place. Like if some company is like showing that it can grow and it will, the stakeholders come like resolution applicant are interested to buy that. So that might lead to revival of that company and not by selling it off. So this will increase the entrepreneurship. It will increase the business interest. So it was basically to maximize the assets of those companies. Then whatever was, if the resolution fails, it will go in liquidation. Then there is priority of payment. Who will get that? Whose debts will be cleared first? So there is a proper waterfall mechanism, how the debts will be cleared. First IBC proceedings payment will be paid. Then secured assets payment will be paid. In this way, there is a waterfall mechanism, and it is like given every step who will get the payment first. Then this code is also aiming at establishing of a board, insolvency and bankruptcy board, who will take care of all the matters which are connected to this code and incidental. They will do the brainstorming. They will see whether these provisions are viable. They will give suggestions. They will invite suggestions. For example, at the present what is happening, the home buyer situation is very pathetic. They are these builders are going in liquidation, and home buyers' interest is at stake. So there are discussions rightly going on to have separate provisions for the home buyers. It's a very interesting thing also. So what was the legal framework prior to IBC? Companies Act was there, which dealt with the binding of provisions was there. Then SICA Act, the primary objective of the SIC Industries company was to identify the SIC companies and wherever it was possible, closure. It applies only to SIC industries, not to the normal industries. It applies only to SIC industries only. Now, whatever the moratorium period was given under SICA, what is moratorium period? The time when the proceedings are going on under these acts. During that time, all the other legal proceedings will be stopped. The company will not, like the creditor cannot take any action against this company in other acts. So this moratorium period was highly misused in the previous acts. So the amendments were required and made in SARFAESI Act, because here in SARFAESI Act there is no relation to the no relation of court. Court cannot play any role. Here the creditor himself takes the take action in the SARFAESI Act. He can sell off the secured assets of the debtor. RDDBI Act. Here you have to approach DRT for your clearing of the default. You will file OA. So what was happening here? Why this act was not giving proper results? Because of the lack of infrastructure. The DRTs are in place, but the officers are not competent. They don't know how to apply the law because they are not that qualified. They are not given salaries. They are overburdened. So all these factors led to the failure of these acts. Even today, if we file one OA, it takes years and years to settle it. So we have to linger on for our own, the defaulters are running away and we are running after them. Amendment pursuant to SARFAESI Act gives creditors to enforce security, but still even the SARFAESI Act could not be successful because the auction was made, so there was no bidder. So all these things led to the failure of these acts. Then framework for small industries, MSMEs were there in 2006, but that also did not contain any provision of insolvency. So all these factors led to the development of a code of the IBC. In SARFAESI Act also, we can take action only against these secured assets. We will selling it off basically. So we are not aiming at protecting that concern, like making it a going concern. We have just to sell it off. Whatever market rate it is given, let us sell it off. Then there was framework for resolution of the LLPs. Limited liability partnership were registered under 2000 Act, and they had also no provision for insolvency. So that has also there's this LLP also has also been included in the IBC. Now, what are the principal features of the code? This code basically deals with insolvency proceedings of corporate persons, partnership firms, LLPs, and first it will deal with resolution, and if resolution fails, then liquidation. So basically there are two heads. It's not a small head, but basically we have to understand that this code has two processes, resolution and liquidation. If resolution fails, obviously the company will go in liquidation. How the insolvency gets triggered? This trigger is known as default. When the defaulter creates default. What is default? They fail to pay the legally owned debt. If the bank or a IFC or a FC gives a loan to the debtor, and if he fails to pay that legal debt, then default occurs, and immediately the insolvency can be triggered. It can be started by filing of an application before NCLT. Now NCLT will admit that application or not. That depends on the fact and circumstances which will be dealing in the next modules onwards. If the attempt fails, company will go in liquidation. What are the features of the code? While winding up of the companies under 1950 Act could be triggered by inadequacy of the debt, and rehabilitative process under the SICA was triggered once the worth of the company eroded. But under IBC, only simple payment default of minimum 1 lakh, but now it has extended to maximum of 1 crore. This has been added by the amendment. Process of insolvency starts on the date. These dates are very important. Why? Because there is a time limit. 180 days ka pura time limit hai. Each and every process is covered under those 180 days. That I have dealt very, very thoroughly in the next modules. Now when does process of insolvency starts? Once the admission of the application by the adjudicating authorities, NCLT. Once it admits that application, on that date, insolvency process starts. Now, another departure from earlier laws was that earlier debtor was in possession. Now, creditor has entire control. Hence, once the process starts, the power of the existing board of directors of the debtor goes in the hands of IRP. Our existing boards of directors, they are suspended during the process of CIRP, and creditor approved IP, insolvency professional, is appointed to manage that corporate debtor as a going concern. So the crux of the matter is the creditor now is in control through the IP. Debtor has to sit aside. Now debtor has no role. He will be sitting aside, and now the entire control is with the creditors, because it was a creditor money who was in stake. It is a public money which is suffering. Hence, once the process starts, the board existing is suspended. Now the IRP will take hold of that concern as a going concern, and entire thing is decided by the committee of creditors. What is committee of creditors? It's a committee which comprises of all the financial creditors. Suppose there are 4 banks which have given the loan. So those are the financial creditors, and they will form that committee of creditors. It's a collective mechanism. Basically, IBC is a collective mechanism for maximizing the value of assets. Hence, it proceeds moratorium period or calm period. What is moratorium period? That in that period, you cannot take any legal action against the corporate debtor, because already the proceedings are going under here. If we take simultaneous proceedings under DRT and SARFAESI, then what is the fun of this IBC? The property is the same, so you cannot sell it off there, because if you sell it off there, what will be the how the remedy will be carried out in IBC? Then corporate insolvency resolution under IRP achieved with a resolution plan, which may be proposed. What is resolution plan? This will be proposed by the eligible person who is not necessarily a debtor or a promoter, and which needs to be approved. The resolution plan means how the resolution will be done, how the default will be cleared, what will happen of this company. Everything is given in that resolution plan. And who will approve it? COC, Company of Creditors. And after that, it will go to the adjudicating authority. These abbreviations, that is why I discussed in my first slide, because these terms will time and again come in our PPTs. If the process of resolution fails, CIRP, corporate insolvency resolution professional process fails, then liquidation process will start, and that order will also be passed by the adjudicating authority, that is NCLT. Now, IBC also creates infrastructure to help the objectives. How the infrastructure is created by the insolvency board? IPs are appointed. Then there are various bodies. The insolvency professional bodies are appointed. They are engaged with the enrolling of IPs to conduct. Who will conduct this IBC process? Professionals. So these professionals will be appointed by the IBC board. Then information utilities, where all information relating to the proceedings are stored in the information utilities. Which have already been discussed, it's a national company law tribunals. They are tribunals which will take care of entire proceedings and under the company's law. And appellate authorities, if the NCLT has passed an order and if the person is agreed, where we will go? To the higher authority, that is NCLT. And if NCLT has also given some order, we can go against that order in highest court, that is Supreme Court of India. Then board, what does board does? IBC code should be read in, IBC code cannot be read solely. It has to be read with the relevant rules, regulations of the code. We have to read every circular. So I will give you a suggestion that whosoever is interested in wanting the IBC, they must go through the website daily, because it's so dynamic, this act is so dynamic that you have to keep yourself updated. It has left the procedural aspects. So procedure keeps on changing day by day. So you have to be very thorough. What are the amendments which have basically been, there are 3 amendments which has been carried so far. The first amendment into IBC was carried out in 2017 by way of ordinance, primarily dealt with the amendment and introduced the section 29A to IBC, which sets out the ground for the ineligibility of the resolution, which resolution applicants are ineligible to take part in IBC is given under that. Second amendment was made by way of ordinance, which brought about 3 changes, like balancing interest of home buyers and micro, small and medium industries, promoting resolution over liquidation, streamlining the provisions relating to the resolution applicant. Now, when this case of JP came up, very important case, earlier the home buyers were not given any category. They were not under the category of financial creditors. So where they will file the claim when the company goes under liquidation? Suppose JP went in under liquidation. So how the interest of these home buyers will be protected? So that is why amendment was carried out in IBC. And now the home buyers are under the category of financial creditors. They can also file their claims if the company is liquidated. The Insolvency and Bankruptcy Code Ordinance 2021, very recent one, was promulgated in 4th of April 2021 as an amendment to Insolvency Code, introducing novel pre-packaged insolvency resolution process. But this has not still been notified. So after this module, everyone will be able to answer these questions. What is the need of IBC? How many amendments have been carried out? What is the objective of IBC law? So this module is very basic, but it will give you a framework why this code came up, and you will be curious to know what are the provisions, what is CRP, how it take place, what is the time-bound procedure. We should know about all these processes in our later modules in great details. I hope you like this presentation, and you will be like interested in learning more and more ideas. Thank you.
Thank you, ma'am. Thank you for another wonderful session on IVC. And I hope the academicians, students, and professionals would get benefit from this session. Thank you so much.